Good morning, everybody. Welcome to my presentation. My name is Raluca Soica, and I'm a wills and estates lawyer. And today I'm going to present on a very interesting topic of the intersection of estates and real estate law. Real estate is a very important part of estate planning, and I always address it with my clients in our estate plans. And I thought I should share some thoughts about some of the things I discussed with my clients during our meetings. Let's look at manners of ownership of real estate. So the first one is one can own their property as a sole owner. And there's a couple of ramifications to that. So the sole ownership is very common again among senior homeowners, especially owners who are widows or widowers, or even if they have a new or second spouse. A sole ownership is common also when one spouse is an entrepreneur or might have had creditor issues. So let's have a look at what happens at death. So if there is a will, then the property will be transferred pursuant to the will. And if there's no will, then it will be transferred pursuant to the Succession Law Reform Act. I'm not going to go into the details of the act, but I do want to say that whichever way, whether there's a will or no will, for sole ownership, there will always be a need, or I shouldn't say always, there are some exceptions. Most times there will be a need for probate. So that means formal application in court for certificate of appointment, and that means also the payment of something called the estate administration tax. So that's why a lot of people look at different forms of ownership other than sole ownership. Okay, so the next type of ownership is tenants in common. As tenants in common, it's not just two people. There can be as many tenants in common as one wants, really. In this type of ownership, each co-owner takes title to a specific percentage, totaling 100%, but it's a divided interest in the property. So that means that each individual owner owns it separately from the other. So they could own it at 1%. One owner can be owner of 1% and the other can be 99%, which is not the case with joint ownership, which we will talk about next after this. And very important is that this divided interest gives each tenant in common the right to force a sale of their share. May not be very feasible, they may not find a buyer, but it is allowed. Now let's talk about what happens at death. So if there is a will, then the owner can actually give their share of the property. They can bequeath it in their will. So even if they own 1%, they can leave it in their will to somebody else. And guess what? The other tenant in common, the survivor, will then have another owner on title with him or her after the first one passed away. And there will be a need for probate because the tenants in common does not offer right of survivorship. If there is no will, then the person's share will be distributed in accordance to the Succession Law Reform Act and the beneficiaries that fall under the act. And then there will also be a need for probate. But there are certain issues with owning property as tenants in common. For example, rights of possession. Do all owners have the right to inhabit the home? May they do so with a third party who is not an owner? Maybe the other owner has a say in this, right? Carrying costs. Who pays for the property taxes, insurance premiums, maintenance, repair costs? The common areas, who has the right to use the common area? Mortgage, there's joint and several liability for each owner by mortgage lenders. Let's look at death. As I mentioned, if a tenant in common dies owning, for example, 50%, this 50% can be bequeathed in a will, and then the ownership will change. And is that okay with the existing owner on title? But the one good thing is that in the event of default, it doesn't extend. In the case of if one of the tenants in common has problems with creditors, the creditors can't access the percentage that they do not own, which is not the case with joint tenancy. And I always like to suggest to my clients that they have a comprehensive ownership agreement and they discuss the topic of what happens at death, so everybody is very clear. The third type of ownership is joint tenancy. This is very popular among legally married spouses. At death, it provides for survivorship rights, which means that the surviving joint tenant takes title by right of survivorship, with some exceptions, which means no probate. And that means that there will be no estate administration tax payable on the transfer of property. Just a very, very simple transfer at the legal office, and it doesn't even cost that much. And there's no land transfer tax payable either. So a lot of people think that this is the solution to all of their problems, and they want to start adding all of their children and their spouses and their dog to title. So we skip probate tax, estate administration tax. But unfortunately, it doesn't, that's not the only consideration. Sometimes estate administration tax is a small price to pay to guard oneself or to guard the property against a multitude of risks. For example, if the home is a matrimonial home of a couple and is owned between one of the spouses and a third party, okay, so the conditions are, it has to be matrimonial home and it has to be owned by one of the spouses and a third party. When one of the owners passes away, the joint tenancy is severed at death. So it's because it's a matrimonial home, and then there will be a need for probate. So that's an exception to the survivorship rule. Another one is what if the co-owner is an adult child? So a home is owned between a parent and an adult child. Forget about whether it's a matrimonial home or not. Oftentimes, and this is often the case if there are more children, if the parent has more children, let's say the parent passes away and then the child theoretically gets right of survivorship to the home. But that's not always the case. And the exception is if one of the children bring a challenge to prove that the testator really had intention to give this property to the surviving child, then there may not be proof. Then there's something that's called a resultant trust, which means that the property results back to the estate and not to the survivor, in order to be distributed presumably between the rest of the children if there was a will or in accordance to intestacy laws. So that's a very, very popular question that I get asked by many of my clients. And then of course, joint tenants get exposure to the debts of other joint tenants. So that's a risk with the house. Yeah, so this is, I just spoke about this earlier. Should one add their child to avoid probate? Not always a good idea. Always, always, always talk to a lawyer. The lawyer can help you assess whether this is the right option for you or not. The lawyer will look at all the other circumstances in your life, will ask a lot of questions, and then bring a recommendation. And sometimes, you don't get me wrong, sometimes it is the right way. If there's only one child's not married, and maybe, or married, but the marriage is going great, maybe it's a good idea. And maybe in that case, it's worth it to skip the estate administration tax. So final thoughts, property ownership is an important component of one's estate plan. So make sure that whoever does your estate plan addresses this very, 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 very important topic. The reason why it's so important is because the prices of real estate are quite high, and every estate that owns real estate is basically a millionaire nowadays, especially in the Greater Toronto area. And this can be the cause of litigation between beneficiaries or potential beneficiaries. So giving real estate significant consideration during the estate planning process is not only indicated, is not only a good practice, but it's also indicated. So I would like to stop my presentation now and ask if you have any questions.
I have a question.
Yes.
Okay, so I often come across clients that are looking to get into the A space but don't qualify. And one thing that comes up with them pretty often is, the option to add another person on title so that we can utilize their income towards qualifying them in the A space for the mortgage. This is where I always recommend for clients to consult with a lawyer because, you know, exactly what you presented on, but just curious if there's a better way to articulate that to my clients to help persuade them to go talk to a lawyer. If there's, you know, just a little tidbit, because clients are dismissive. They hear there's a way to get into the A space and they just want to go for it. And I'm like, really, you need to consider this option carefully. So I would love to hear your thoughts about that.
Right. So there is an alternate solution for property ownership, which is a little bit more in detail. So I didn't address it here. Property can also be owned as in a trust. So independent of the manner of ownership. So independent whether it's tenants in common or joint tenants, we can also work with a trust at the same time. And this is actually sometimes done for estate planning purposes, and some banks allow it. And what a trust does is that if a person is added to title only for mortgage purposes, then the trust allows the other owner, who's really the true owner of the property, to own the property beneficially. So from a beneficial perspective, fully. So that's what the trust does. It says that even though there's this one other owner on title, really they're holding title in trust for this beneficial owner. And but there's caveats with that and some risks with that as well. And not every bank allows it. That's a good tool to use when the circumstances facilitate it. Otherwise, I mean, if a person is added to title and that's the only way that the client can qualify to purchase a home, then they need to be made aware of the risks of, and it depends on how they decide to own title, whether it's joint tenants or tenants in common, and what their family situation is. But there is quite a bit of risk if one of the owners is married, especially if they live in the home and it becomes a matrimonial home. Let's say the child is added to title to help the parent, or the other way around, and then the child is married, but they're only living in the parent's house kind of because the parent is allowing, you know, them to live there because the real estate prices are so high. Well, guess what? That then becomes the matrimonial home of the child, and the spouse now starts to have access to the child's share. So a lot of consideration and risk, and they should speak to a lawyer. Yeah, I would just say, to articulate that there is a lot of risk that they're not aware of is not very clear cut and simple.
Thank you. Yeah, no, I definitely tried to convey that, but it's good to hear the different options.
And anyway, once the mortgage instructions are out and they get a real estate lawyer, the real estate lawyer should explain to the risks anyway. Even though it's a done deal and the real estate lawyer came in at a later time, the client should still be aware of the risk.
Absolutely. Unfortunately, I've had a lot of clients that have that lately have been geared towards using FNF or FCT. I don't know if you're familiar with them, which is part of my difficulty lately. It's been a bit frustrating from the mortgage perspective because they actually don't go through the legal paperwork with the client the way they should. So it's part of the issue, and why I've been trying to persuade my clients to not go that way, but it's a little more cost efficient for them. So anyway, thank you, Raluca. I appreciate it.
No problem. Any other questions?
I've got one, Raluca. It might be somewhat similar. So I deal with a lot of older people, and my demographic of my age and my friends are getting to that point where they might have parents who no longer have a spouse or just alone in their own home, and they're thinking about adding the kid onto title just to sort of help administer the estates. But the question is if, for example, somebody already owns a home and then they get added to mom or dad's home, what happens with the principal residence and the capital gains? And, you know, Phil might have to help chime in on this because I get asked this a fair amount. So how does that sort of play into this? Yes, we're doing it for the ease of the estate, but it may also screw somebody on the capital gains exemption type stuff.
That's right. Yeah. So as soon as a person gets added to title who does not live in the home, then the share of that person, so whether it's 50% or less, depending on how they own it, that share becomes subject to capital gains. Capital gains will need to be payable, I guess, when that person passes away. And so there is capital gain that accumulates on it. I don't want to expend too much on it because I usually give tax advice, only tax information. So the most important thing to know that I would recommend that you tell your clients is that as soon as you don't have a person who is who lives there, who has their primary residence there, then that will give rise to capital gains and to speak to an accountant about it.
Can I jump in for 1 second?
Yeah,
D, you're absolutely correct. It really depends on if they have the other property, it becomes an issue. If they don't own the other property, they can still use, I mean, assuming it's a child or very close family, they can still use it. But if they own another property, it is an issue. And another issue that I'm sure Raluca comes upon is, if you have two people who are cohabiting somewhere and somebody, and they own other properties, if they're considered, like if they fall into the common law, they might lose the ability for that second thing, even if they're cohabiting. So I'm sure, that probably comes up in your stuff as well, Raluca. But yeah, it really comes down to owning the second property.
Thank you so much, Phil, for checking in. Yeah, so there's a lot of considerations when adding a person to title. Yeah, and taxes is definitely one of them.
I had one question, Raluca.
Yeah, go ahead.
You use the word matrimonial home. I'm just wondering if you can explain what that is. And the other part kind of stemmed from what Phil and you guys were just talking about is, so I'm on title with the home that my parents and my siblings live in, but I'm currently living with my in-laws, with my wife and my in-laws, but neither me nor my wife are on title. So is that when we become, so would the home that I'm currently living in be considered the matrimonial home? Or?
So it's only considered a matrimonial home if you own it, if you're on title.
Okay,
so if you don't own it, if you just live there, but like in-laws have title to the home, you live there, but it's not a matrimonial home designation.
Okay.
Yeah, so you need to own it, and that's when rights start extending to a spouse. When it's a matrimonial home, even if, for example, if you had any amount of percentage of title to a home and you and your spouse lived there, then that would be a matrimonial on the share that you own. It would be considered a matrimonial home.
So since I have share in the home that my parents and my siblings live in, but I don't live there, so that's not considered a matrimonial home either.
Okay, this is getting into the realm of legal advice, so I'm trying to stay away from that and keep it general. It seems like it's not, but I don't know more information about this.
Okay, no problem.
I need to ask more questions. I need to look at title in order to make a determination for sure. But even if a spouse owns, even if a spouse owns title to a property that they don't live in with their own spouse, in case there were to be problems and there would be a separation or divorce, maybe that share that the spouse owns where they, in the property that they don't live in, maybe that may become part of the net family property. It depends on so many things.
Okay.
But it might become an asset that would be shareable with a spouse. But again, so many different considerations, and I don't know your exact situation to be able to say anything to give a conclusion on this topic. But just generally, real estate is.
I really appreciate the presentation because, like within the last 15 minutes, I learned so much. So that alone is more than I knew at 8 o'clock today, right? So I really appreciate I really appreciate the
wonderful. I'm so glad that it was an educational presentation. Definitely. That's one of my goals. I want to educate people as much as possible because this is not common knowledge.
No,
people don't
definitely not.
They don't just start Googling this topic or topics like that. It's for fun, right?
Yeah, no, you don't.
Okay.
Thank you very much.
Sounds like Aji and Raluca need to make an appointment and have a more in-depth conversation.
One-on-one.
That's right.
1-to-1, 1-to-1. Yes.
Okay,
Definitely.
so if nobody has any other questions, then I will stop the presentation and pass the baton to Dr. James.